People of the State of Michigan versus Caron Fuller. These are files 2123742 and 2123773. Mr. Fuller is here today with his attorney, Mr. Gibson, and the prosecutor is Mr. Gabriel. And these two cases are set for status conference today with trial later in the month. Mr. Gibson, are these cases ready for trial or are they resolved? What's the status?
Your Honor, the cases are not resolved and we are asking for the trial date to be adjourned. I have, there were two preliminary exams that I have requested the transcripts be made, but we don't have those yet, and I still need more time to investigate. These cases were both, I believe, found over a couple of months ago, but they've, I've only had approximately 60 days to investigate.
All right. Mr. Gabriel?
Your Honor, I certainly understand, and that's correct. I don't believe I have a transcript either. I would just indicate that I did make an offer, and that Mr. Gibson and I have exchanged correspondence regarding a possible resolution. I would just ask and advise that he discuss that. My position kind of going forward is that if we made an offer, particularly if the defendant has made some inquiry about one, I don't intend on keeping it open for status conference on top of status conference. I understand that we have these status conferences, hopefully to resolve cases. If the cases aren't resolved, then we have status conference to make sure we're ready to go to trial. If a case isn't, if the offer isn't accepted, but in this case it's open because we don't have a transcript. But if we come back and it's not accepted, then it's going to be gone. And the next status conference after that, you know, I want to start focusing more on getting ready for trial.
Hopefully there wouldn't be another status conference after that. So for the record, what's the offer to resolve these cases that's made right now that's being rejected in order for more work to be done on the files?
I indicated, Your Honor, that Mr. Fuller could enter a plea of guilty to the home invasion second offense. That is, or second degree, that is in file number 2123773FH. We would then dismiss larceny in a building in the fourth habitual. I would also dismiss file 2123742FH, unlawful driving away in auto. We have recovered the auto, and if no damage was done, fine. If there was, then restitution on that case. And it would be dismissed then.
Okay, so hold on one second. So if I'm right, the offer is in 2123773 to plead to one count of home invasion in the second degree, dismiss the larceny in the building, dismiss the habitual offender fourth offense, and dismiss the other file completely.
With the understanding if there was restitution, we would pay that.
Understood. Okay. And Mr. Gibson, you conveyed that to Mr. Fuller, is that correct?
I discussed the plea. I discussed whether or not the defendant would plead to home invasion second degree, and my understanding was he was indicating he would not be willing to plead to that when we discussed it earlier this week.
Okay. Mr. Fuller, you understand what the plea offer is at this point, correct?
Yes, sir. Yes, sir.
Rejected that. You've rejected that,
yes,
is
sir.
That correct? Okay.
Yes,
all right,
sir.
So with that, then, okay, so it's made, the offer's been made, it was conveyed, and it's been rejected. So we're good to go. Protected Mr. Fuller to make sure he understands what's going on. All right, I'll grant the adjournment on both files, and hopefully the prelims will be done, transcribed, and we'll go accordingly. All right, thank you, everyone.
Mr. Fuller, or Mr. Judge Stutesman.
Yes.
I was supposed to be going today for I filed for a motion of a bond reduction. I was supposed to go on the 23rd of March. My attorney filed for that amendment, and I found he filed for amendment on today too, sir. I thought I've been here for 3 months, sir, and I was told that I was going to be seeing you today for a bond reduction, sir. Too, but
Okay, go ahead, Mr. Gibson.
yes, sir.
Thank you, Your Honor. We did file a written motion for a personal recognizance bond. The defendant has strong ties to the local community. He's been in jail since his arraignment date, it's believed, of March 15th, 2021. But prior to that, he had served approximately 2 months just prior to that on another case. The defendant, if he's released, will reside in Three Rivers, Michigan. He was given a PR bond in district court, I believe, for his other case. And the allegations in this case are not in any way violent. It is a home invasion allegation, which is a crime against a person, but there's a videotape that was played at the preliminary exam of the alleged crime. It was the residents were not home, and the defendant was looking at, apparently through whoever.
I don't want to hear about the facts of the case.
So we would ask that
I just want to hear about the basis for a bond.
Right.
What is the bond? In file 2123742, the bond was reduced to a $1,000 PR bond on March 16th. So you're not talking about that case, obviously.
Correct. This case has a $30,000 cash surety bond.
Okay.
And we would ask the court to consider a personal recognizance bond or to lower the $30,000 bond due to the strong ties to the local community and the facts and circumstances for the court. Thank you.
Thank you.
And also,
All right, so go ahead, Mr. Gabriel.
Thank you, Your Honor. Your Honor, difficult to argue strong ties of the community. And looking at Mr. Fuller's record today, using his criminal history going up to this 2016, I counted 13 arrests. Since then, on our system, there were 13 more arrests. 6 of those started out as felonies. There were multiple convictions. He's a 4th habitual offender. I'm looking at the fact that, at least starting back, it looks like in 2012, attempted R&O and R&O. In 2013, 2 R&Os. In March of 14, an escape. In the on-base system, I mean, Mr. Fuller does tend to stay around, but he stays around and he continues to find himself being arrested and charged. I look at the facts that we have strong evidence, and I'm not going to go into it. Mr. Gibson knows, and the court unfortunately doesn't have the transcript yet. But there is strong evidence of guilt. These victims do know the individual, Mr. Fuller. And the guidelines, given his record, are going to be in a prison cell. I don't mean prison cell, I mean the prison cell grid, in the grid. And I do think that that's going to be an incentive to A, not hang around, B, to continue to, I guess, be a detriment to the community and put others at risk because of its ongoing criminal behavior. I don't know. The only other thing I don't know, and I couldn't figure out, maybe Mr. Gibson knows, the first offense happened back in last year. I can't tell if he was actually picked up and out on bond when the second one happened. I know
He was
at home.
so he was arrested in February on the October incident for 23742, and It says he was arrested and then he bonded on March 10th, 2021.
So he was out on.
And then he is accused of breaking into this home on March 13th, 2021, where it's allegedly on video showing him going into the home of his friends and taking the items from the home. So yes, he was on bond for the one offense. He had just been granted a lower bond, and then this offense occurred. Mr. Fuller does have a lengthy criminal history. He also has a lengthy history of failing to appear for cases. And so I don't find that the bond is outrageous, and he has not met the 180 days yet to ask for a PR bond, and we'll proceed accordingly. I'm not lowering bond. The request for bond reduction is denied.